With this week's module, we turn to the final stage of this course, turning to questions of breach and remedies. Starting with this week's module and continuing for the remainder of the course, we are assuming that we have an enforceable agreement, that is, we have a contract between the parties, and we are assuming we know the terms of that contract, and therefore what the parties' obligations under that contract are. And we are assuming that there are no facts or circumstances that would excuse a party from performing. Now we can focus on breach and the remedies available for breach. What constitutes a breach of contract for the sale of goods? More importantly, what under Article 2 are the appropriate remedies available for breach? Remember, remedies are the means by which parties enforce their rights under a contract. What it means to enforce a contract is to bring a lawsuit against the breaching party and to obtain a judgment, a court order, against the breaching party, specifying the remedy the breaching party must provide to the non-breaching party. But at the outset, it is critical to also recognize, in the real world, parties seldom use litigation to enforce their contractual rights. Litigation is costly and time-consuming, and the results of litigation may be uncertain ex ante. As a consequence, the vast majority of disputes over breach are settled through negotiations by the parties, outside of court, outside of the litigation process. But it is the availability of court-ordered remedies that shape the contours of any settlement negotiations. Stated differently, any negotiations to settle a breach of contract necessarily occurs in the shadow of the legal remedies available in the event of a breach. It is the availability of these remedies that gives the non-breaching party, that is the party injured as a result of the breach, leverage to extract the settlement from the breaching party. Indeed, it is the availability of remedies for breach that give parties the certainty to enter into contracts in the first place, the certainty that if the contract is breached, the non-breaching party can resort to a legal process to wrench compliance or damages from the non-breaching party. Our look at contract remedies will start with the buyer's remedies in the event of the seller's breach. How might a seller breach a contract for the sale of goods? Well, the easiest scenario is where the seller simply fails to tender goods promised under the contract. So, at the time and place the tender of delivery was due, the seller fails to deliver the goods. Or perhaps ex ante, before seller's tender of delivery is due, the seller anticipatorily repudiates his obligations to deliver the goods. The seller manifests her intent to the buyer that the goods will not be forthcoming when delivery is due. A slightly more complicated scenario would be where the seller tenders delivery of the goods, but the tender is non-conforming, either because the goods themselves fail to conform to the requirements of the contract, or because the seller's manner of tender fails to conform to the contract. For example, the seller delivers the goods late or to the wrong place. There is a third scenario that we might just note, where the seller makes a conforming tender of goods, but fails to fully perform some ancillary service related to the sale of goods that is required by the party's contract. For example, the seller might fail to properly install the goods as required by the contract with the buyer. This third category of breach, a breach of services, is not covered by the UCC. For this third category of breach, we would need to look to the common law of contracts, which remember supplements the UCC for the appropriate rights and remedies of the parties. So our focus in this course will be on the first two categories of breach, and in particular, in this week's module, we will examine Article 2's rules governing the situation where a seller simply fails to tender the goods. What are the buyer's rights and remedies where the seller breaches by never tendering the goods that she contracted for? And in covering this topic, this will be our roadmap for this week. First, we will look at the limited availability of specific performance and other non-monetary remedies for the buyer where the seller fails to tender the goods. Then we will examine the two primary measures of damages for the buyer, cover damages and market-based damages. Finally, we will conclude by considering the kinds of additional indirect damages the buyer may recover for any incidental or consequential losses that she suffers as a result of the seller's breach. So with the next video, we will begin our look at remedies by examining the availability of specific performance and other related remedies.